Hello everyone, it's good to have you all on board. It's another time with Tutorial, Fantastic Tutor, and in today's tutorial, it happens to be the continuation of the course ACC411. It's actually a very interesting course. It has a lot to do with reality, and it has a lot to do as well with the law, considering the financial angle. So today, we're going to be taking our bearing from conflict of interest. And we're talking about what it means by conflict of interest, and as well as we'll be considering conflict of interest between what parties. Okay, all of that we'll be considering today, and also be considering the legal perspective to the said topic. So tonight's class might not really be a long one because it's more like a bullet point and expanding tonight. So it might not necessarily be a long one, but let's pay attention to details. Okay. So now, for those of us who are new to the stream, let's do well to smash the like button, subscribe to the channel, as well as turn on the notification bell so you can get notified whenever we start our classes. And most importantly, let's ensure to join the private class. So we'll walk you through everything without leaving anything behind. How do you join the private class? All you need to do is just head straight to our official website, which is www.tutorio.net, and from there get to use the WhatsApp button on the top right hand corner to send us a direct message. So now let's go straight to this class. What we say conflict of interest. First, let's understand what we're talking about. What does it mean by conflict of interest? Now, simply put, when we say conflict of interest, we are simply referring to, we are simply referring to a situation. And this situation happens, or this situation is concerned, all right? The situation happens to be between two parties, which their goals or their aims have become incompatible. Okay? A situation, right, whereby parties see their goal as incompatible. Okay. Now, I said I was going to talk to us about what it means by the phrase conflict of interest. For there to be conflict of interest, at some point, there was compatibility. At some point, everyone was cool until it gets to that point. You begin to see early warning signs, or you concluded that this party involved in this contract, the other party involved in this contract, seems to be breaking the terms of our contract, and therefore we are no longer seeing through the same lenses. Our goals are no longer compatible. Okay, so now, based on this definition, let's now talk about the parties. Okay, the parties in particular. Speaking of which, conflicts between members and clients, members of ICANN, Institute of Chartered Accountants of Nigeria, conflict between members and clients. ICANN members of firms should not accept to what? To continue. Are we together? They should not accept to continue, okay, to continue an engagement where there is a conflict of interest. Okay, ICANN members of firms should endeavor to stop, should endeavor to discontinue, should endeavor not to accept, should endeavor to discontinue, or should endeavor not to accept or continue an engagement, should not continue an engagement. Okay, where there is a conflict, an engagement where there is a conflict, okay, of interest. I will explain this as we continue into this class. Conflict of interest between the member, all right, or firm and its clients. Don't forget, accountants, the auditor, or the organization of, or the organization providing the assurance services. Wherever there's a conflict of interest between them and their client, it is best advised they withdraw the contract immediately. Now, let's take note of this. When members compete directly with a client, the receipt of commission from a third party for introducing, all right, for the introduction of a client. For example, an accountant firm may be paid a commission by another entity because they refer, all right, they refer a client to them. Now, this is what we're talking about. In situations whereby you got an offer or an employment from a particular firm to audit their book of accounts, or in a situation whereby another firm refers, all right, a member. Either of these cases, wherever you and your client have what we refer to as conflict of interest, you are best advised for your own safety to terminate that contract. Now, what are the safeguards in a situation like this? You as an accountant, all right, you as an auditor, what are the safeguards? Now, let's take that. Safeguards. Now, as an accountant, you should have procedures like this in place. First, identify possible conflict of interest situation. There's something we call early signs or early warning signs. Even before you go into the contract fully, you should be able to read in between the line. All right? You should be able to identify possible. You should be able to identify possible conflicts of interest situation. Identify possible conflict, all right, of interest. What am I saying, SS? You can tell that these clients I'm going into contract with might give me issues, especially noticing certain signs. All right. And what these signs are telling you directly is that to avoid possible conflict, when you are already getting signs like this, you are best advised to withdraw. Also, evaluate possible problems. Okay? Evaluate possible problems. Now, we said something at that time. As an agent offering assurance services, as an accountant, or as an auditor, you have to work independently. There are standards you must follow. There are code of conduct and ethics guiding your every action. And most importantly, you must work without influence. You must work independently. Why? Because if you are certifying, you are verifying books of account, it is 100% accepted, because according to the ethics, what you say holds water. What you say, all right, should be taken based on the fact that you are assumed to have done due diligence by working under, all right, your code of ethics and professional guidelines. So you as an accountant, knowing all, you as an editor, knowing all of this, and your client seems not to let you work at will, not providing with necessary information, or trying to put you under undue influence, then you should be able to evaluate that this is a possible problem. And for the sake of your license, for the sake of your reputation, you are advised to withdraw. Okay? So let's just pick one more. It says, review relationship with all clients on a regular basis. Review relationship. This is a matter of over familiarity. You know, there's a point you get to with a client because it's become regular patronage. There's a level you get to, you become over familiar. All right? Or boundaries might be crossed, or you might feel relaxed around them. Based on your profession as an auditor, as an accountant, or agent that offers assurance service, you need to always put yourself in check, review all relationships, and ensure that you are on the right spot. So we have that as that. So let's see the legal position. Okay. the legal position of the auditor. Now, we are still talking about conflict of interest. Okay, so let's go straight ahead to the legal position of an auditor. Now, under this legal position, in a situation whereby the client has proven very difficult, all right, and the table seems to be turning against the auditor. Legal position of the auditor. In situations whereby it seems like the table is beginning to turn against the auditor, there are legal positions. Okay, so let's start with professional liability. Under legal position, we have professional liability. Here, professional accountants may have professional liability under what we refer to as common law, all right, as well as statutory law. The liability here is that the auditor may be criminal based on the yardstick of the contract. Now let's look at it like this. Criminal first. The criminal liability here means that criminal liabilities arises out of statute. Now, under certain statutes, under section 560 of CAMA, if any person in any return, report, certificate, balance sheet, or other documents require the purpose of any provisions of the Act, willfully make a statement that is false. Okay? False statement. Here, willingly, not coerced or forcefully, but willingly makes a statement that is false in any material particular, knowing to be false, he is criminally held liable and may be imprisoned for 2 years if convicted by a high court or fined 1,000 naira, or 4 months imprisonment if convicted by lower court, or both such fine and imprisonment. That's what it means by criminal liability. So that means you, as an auditor, your profession does not allow you to falsify statements. And if you go ahead to falsify statements, you've gone against your, all right, you've gone against your ethical standard and principles. So you are to face the law. Another civil liability, it arises under contract. Okay? Contract or tort. Now, civil liability under contract. Civil contract or tort. Now, the audit client, the company has a contract with the auditor. Definitely. There's always a contract with the auditor. A contract for the supply of services such as audit has a duty of care. All right. This duty of care, we are simply talking about the legal obligation to act with reasonable care, all right, to avoid causing harm. It is your responsibility as an auditor that you protect the financial interest of the organization. If there are any errors, you report them that they may be fixed or traced. So that is one of your responsibility under the law. So it is called duty of care. Now, under the contract now, a contract for the supply of service as audit has a duty of care implied by the statute. That is, duty of care is automatic and need no proof, in as much as you have been offered that job. Now, in a case of this nature, only two elements need proof, and they are whether the duty of care has been breached, whether any loss has risen as a result of the breach. All right, we have duty of care breach. All right, or loss out of duty of care breach. If indeed you are given the responsibility to watch over, you are given the responsibility of the duty of care of a company's finance, and with under your nose, look, something went wrong, you'll be held responsible. Okay? You'll be held responsible. So that's under contract, and the same thing goes for tort as well. Now, for tonight, I want to talk about under tort, we have negligence. Okay, as I said, both goes for each other. Now, this is more like an act of omission, which occurs because a person all right, the person concerned failed to exercise that degree of responsible skill, negligence. So we have that as that. So in our next class, we review certain case laws in line with what we are discussing, all right, on how some providers of insurance services, auditors, and accountants has failed in doing their duty, and what the law has, in this case, what has been done to them. We'll be reviewing case laws, all right, in our next class. So thank you very much, everyone. So let me give us an assignment very quickly based on what we have learned so far. So I want to ask us these questions. Please let's ensure to submit our assignment to the appropriate quarters. Okay. We have assignment 01. I'm not mistaken. I really need to change this my markers. They are all running out already. Fading out already. Now, who is an auditor? Okay. Who or what is auditing? Who, what is assurance service? Okay, what else do we have here? What do you understand by conflicts of interests? So that's it. That'll be all for now. Thank you very much, everyone. I believe you'll be able to gain something in tonight's class. Let's ensure to attend to the assignments and send it to the appropriate coaches. I look forward to seeing you on the tutorials. Bye for now.